Back, time to take up your legal questions on the Property Show with our legal expert Yogesh Singh, partner Trilegal. Yogesh, thank you so much for joining us. Let's kickstart this edition, and we have Akshay Garg on the line with us. Hi Akshay, what's your question to Yogesh?
Yeah, hi Vasudha, hi Yogesh sir. I actually have a question regarding one property which I have recently bought in Sector 1, Vasundhara, Ghaziabad. The problem is I bought the property and I have got the registry with me, but we have there is one mistake which has happened in the registry. The name of the builder which has sold me the property, the spelling of the builder name is got wrong in that registry, and but the stamp and the signature of the director of the builder, the company, is correct.
Okay.
So, is there any problem in the future which I might face if in case I will be selling out the property? And secondly, with the same question, I have asked my dealer, the property dealer which made the deal. He gave me 100 rupees stamp paper on which he has got this in writing from the builder that his name has by mistake got the spelling mistake in the registry.
Okay.
And I have all the right to sell and use that property. And there would not be any problems from the builder end. So he has got me in written on 100 rupees stamp paper.
Okay, okay.
Please
so,
let me know.
Right, we get your point. Okay, so a factual error in his registry, he has a stamp paper which refers to the mistake, tries to clarify the mistake, but is that the correct procedure? Is he now foolproof?
So he's got the stamp paper. What he needs to do is ideally write up a rectification deed on the stamp paper and get it registered with the same registrar where he got his original property papers registered. That would make the whole process foolproof. In the absence of that, getting a declaration from the builder that the name was an inadvertent error should also generally work. But if you want a foolproof recourse or a solution, then I would suggest get a rectification deed executed and get it registered. The stamp duty and the registration fees for such a rectification is fairly nominal. You will have to explain to the sub-registrar that it is only an inadvertent error and just a spelling mistake which you are getting corrected rather than any substantive change, so that no incremental or high stamp duty is attracted. But other than that, just get a execute a registration deed.
Okay, so it's a rectification deed that you need to look at. Okay, next we have an email by Mohan Rangan. He writes, there are 100 people who invested in a project by Jain's Housing in Bangalore. It's a 7-year-old project and there are about 50 villas which have been left unfinished. The clubhouse is also under construction. Buyers have either paid in full or in partial. There has been no communication from the builder on when he plans to complete this project. They approached CREDAI but no response from the industry body. Mohan Rangan says senior citizens with no regular income have invested in this property and they cannot fight a continuous legal battle. The builder is also not entertaining any request for a refund. What should they do? Yogesh, any recourse outside courts for them?
So outside courts, I think the remedy that they really have is they can write to the local authorities, write to their local MLA, get them involved and try and apply some pressure on the builder. But other than that, I think given the situation where they are, it is very likely they will need to adopt one or the other legal recourses where they have plenty of options.
Okay, and I'm sure the state's local laws, apartment ownership laws, will have some kind of recourse, some kind of
yes.
Penalty clause for them.
Yes. So under the Karnataka Flat Ownership Act, there is a specific provision where in such case, in a case of a delay of handover of possession, the flat owners have the right to claim a refund along with a simple interest of 9%. It's also possible, so they may adopt recourse under the Karnataka Flat Ownership Act. They could also approach consumer forums and try and claim a refund or at least stop making any future payments and go to court and seek a direction so that the project is completed at the earliest, and in the meantime they are properly compensated for the loss that they are suffering. Consumer forums would also be a good option, but like you said, there's a very specific provision which will definitely come to their rescue in this case.
Yogesh, would that be your blanket advice to all those who are, stuck in some apartment project? Study the state's local apartment laws and, compare it with your builder buy agreement and see which are the areas where the builder has underperformed.
Yes, absolutely. I would say look at the local Flat Ownership Act or the local Apartment Ownership Act and look at what are remedies that are available. But in addition to that, I would also recommend that even if suppose you do not have any specific remedy under the local Apartment Act, you would have recourse under Consumer Act because this would qualify as a deficiency of service. And at least in the NCR, we've got 2-3 Supreme Court judgments or judgments from the National Consumer Forum as well, where full refund has also been allowed. So there is certainly, the courts are looking at this favorably, given that they understand that the buyers are a bit of a helpless lot here. And clearly the case law and the trends that you have are encouraging and are helpful, I should say, in terms of providing some sort of relief to flat buyers who are in similar situations.
Okay. Very quickly, we'll get to our last question in this segment. We have Sushil Vasan, who says he wants to know, can an NRI holding an OCI card buy property? How does an NRI handle the TDS matter for property which is worth over 50 lakhs? He says the NRI in question does not own a PAN card and is not an income tax payee. Yogesh, what does he do?
So NRIs and PIOs are both eligible to buy IMUL property in India. There's no problem with that. What they can't do is they can't buy agricultural land, farmhouses and plantations, but they are otherwise eligible to acquire immovable property. As far as the question of TDS is concerned, there is no exception. The NRI concerned would have to apply to the income tax department and seek and obtain a PAN, which is not a very difficult process. I would think it's a process which should not take more than a month on the outermost. Also, as far as concerns regarding if the NRI holds a PAN, does that mandate tax filing or paying tax in India is concerned, I should clarify that the holding of a PAN itself does not lead to tax liability in India. So therefore, the NRI can buy the property, but they should obtain the PAN in advance.
Okay, so those were the legal queries we'll be taking up this week. You can always write into us at property@ndtv.com and we'll get our experts to answer on your legal dilemmas. Yogesh, always a pleasure to get your legal inputs. Thank you so much.